Welcome back to Winning Isn't Easy. What are disability insurance carriers or plans looking for in your medical records in determining your functional capacity? Now, let's look at how disability insurance carriers or plans evaluate your medical evidence. When you file a claim, one of the first things the disability carrier or plan is going to do is to request your medical records. And when they get them, they're going to review them cover to cover. Now, you need to understand these days that they are using AI to do medical summaries. And they're probably giving the AI certain queries about what it is they're going to be asking it to look for in terms of your medical records. One of the things they are looking for is a long-term relationship with your doctor. Even though the ERISA law does not give a special weight to treating physicians, I find that insurers will give more weight to records from doctors you've seen consistently over time. Now, that doesn't mean to say that they're going to defer, because there is no treating physician rule in the context of an ERISA case. But regular visits show continuity of care. The second thing they're looking for is detailed documentation of your symptoms. Now, saying that you're fine at appointments can seriously damage your claim. What's an insurance company or plan going to do in interpreting that term? Well, they're going to interpret it as proof of improvement. So instead, I think you should be describing your symptoms, whatever they are, be they pain, fatigue, cognitive issues, in terms of how they interfere with your activity of daily living. For example, if you've got migraines, you want to be able to go into the doctor and say, look, since I last saw you, I've had 6 migraines. They've each lasted 3 days. I've been in a cool, dark room with compresses on my head, no noise. I vomit. I'm nauseous. I can't eat. When the migraine ends, I feel like I've been run over by a truck. So I feel like I've got to add another day to recover from the migraine. And this is how it impacted my ability to function. I didn't eat. I couldn't cook, couldn't take care of my kids. So that the doctor has an understanding of the symptoms and has an understanding of the functionality. Now, there's also a flip side here. I told you that disability carriers or plans will pay attention to the physician's records, particularly if they've treated you over time. But if your doctor says the same thing over and over in your medical records, that's a problem, because the disability carrier plan can't figure out what's going on. How can this person necessarily have the same exam findings every visit? How can the complaints be the same? How can the treatment be the same? How can there not be any change in the treatment modalities? How come there isn't a referral to a specialist? So the same rigmarole, if you will, that you see in medical records can be a problem. Number 3, they're looking for consistent treatment and compliance. Regular visits, in my view, prove ongoing disability, but skipping appointments, refusing treatment without explanation, or stopping care altogether is a no-no. That leads insurers to assume that you've recovered. Even if your doctor says that there's nothing more they can do for you, you still should have scheduled visits to document your condition, that interval history of symptoms and functionality, your response to treatment or the lack of response to treatment. What we're looking for here is documentation of symptoms and functionality, and certainly the doctor's continued recommendation that you do certain things to maintain your functionality. They may suggest that you continue to engage in continued home exercise, or to attempt to swim, or to do other things. So just because the doctor isn't necessarily offering palliative care doesn't mean that you shouldn't be seeing them. In fact, what you probably should be doing is asking them to make referrals to other physicians for further evaluation and treatment. Now, that leads me to number 4, specialist involvement. Carriers prefer evidence from specialists. So if you have Parkinson's, MS, fibromyalgia, migraines, cardiac issues, they want to see treatment notes from a specialist. They're going to carry more weight than the records from a primary care doctor or a chiropractor. So when possible, we want these specialists to complete the APS forms and those applicable residual functional capacity forms that we Social Security lawyers use. Now, beyond your records, what's going to happen is that the insurance company or plan is going to conduct their own analysis of your residual functional capacity across physical, psychiatric, and cognitive domains. They're going to send your medical records to their liar-for-hire peer review nurse or doctor and ask questions about your physical residual functional capacity. And that is how long you can sit, stand, walk, how much you can lift, whether you need to change positions, whether you have problems with bilateral manual dexterity. And they're going to ask the doctor to come up with their own opinion about your restrictions and limitations. They will cherry pick your doctor's medical records. They will say that the restrictions and limitations assigned aren't supported based on your physical exam findings, the diagnostic studies, your report of your own activity, whatever it is they can find to cherry pick the records. They're also going to send, as appropriate, your medical records to a psychiatrist for a determination of your psychiatric residual functional capacity. Among the things that a psychiatric RFC measures or attempts to quantify is your ability to handle stress, to adapt to change, to get along with others, to maintain focus, to handle simple, routine, repetitive tasks, or to accept criticism in the workplace. And I will tell you that, again, the liar-for-hire peer-reviewed psychiatric reviewers will cherry pick and criticize the records. They'll say something like the person's not necessarily compliant with the medical treatment, or if the person really had the level of psychiatric symptoms of which they're complaining, they would be in a hospital, or the treatment would be more frequent, or the medication would be different. So cherry picking is going to be seen even at the psychiatric level. It gets worse, I think, when we get to the cognitive issues. Cognitive residual functional capacity is your ability to concentrate, how your memory might be impacted, how your executive functioning might be affected. And again, they're going to use liar-for-hire psychologists or neuropsychologists to say, look, this person showed up at the doctor's office and had a normal mini mental status exam. Like, that is really determinative of anything. That asks questions like, what day is it? What month is it? Who's the president? Sort of stupid stuff. That mini exam in no way measures your cognitive abilities. What they're looking for, again, is medical records that document your psychiatric functioning or your physical functioning, and how pain or psychiatric conditions might impact your cognitive functioning. If you've got PD or you have MS, you're going to have neurocognitive issues. If you've got Alzheimer's or early onset dementia, you're going to have cognitive issues. So they're going to be looking for neuropsychological testing. There is a bit of a trap here, because in that testing, the neuropsychologists are also going to be determining whether you have depression or anxiety that is contributing to your disability or the diagnosis. Remember, we've talked about the 2-year mental nervous policy limitation. And if you've got one of those Monty Python mental nervous policy provisions, you can be in trouble here. Why is that? Well, what happens here, remember, is that in the Monty Python mental nervous policy limitation, if a psychological condition like depression contributes ever so slightly to disability, benefits are limited to just 2 years. And depression can be a factor in cognitive issues. What happens here, of course, is that the disability carrier plan is going to refer your case to their liar-for-hire peer review doctor, who is going to second guess your cognitive impairment. Generally, they'll say that your complaints or the exam findings or the diagnostic studies just don't demonstrate the level of severity of your complaints, or that there's no objective basis for them, or, it's all psychologically induced. You can see how denials can be based on the peer review doctor's analysis of your medical records. That's why I think it's critical to have your own doctor's complete residual functional capacity forms and ensure that your records are fully documenting your symptoms. And without that, in my view, the disability carrier plan is controlling the narrative. Remember, if your claim is denied, you'll only have 180 days in which to take an appeal. And during that time, it is really essential that you strengthen your medical evidence, attack the carrier's review, attack those desire for higher peer review doctors, present your RFC clearly, get any testing that could document or corroborate your level of functioning, hopefully have your doctor endorse it or get the statement, get statements from family members, friends, maybe even co-employees. All of that goes together in attacking the wrongful basis of the denial or termination of your claim. Remember, you want to be attacking the factual basis, the medical basis, the vocational basis, and of course, the legal basis. Clearly, an ERISA attorney such as myself can coordinate with your doctors, get the necessary medical evidence, develop the necessary medical evidence, develop the necessary vocational evidence, challenge policy limitations, and build the record to overturn the denial. Remember, in an ERISA case, that appeal is the trial of your case. So once the appeal process is ended, you really can't add any new evidence. There is no trial, and you don't get your day in court in an ERISA disability case. In other words, there's no jury trial. Most of these cases are decided on what's called a motion for summary judgment, which are legal pleadings that the lawyers exchange. I want you to remember, it takes teamwork between you, your doctors, and your legal team to secure and keep your long-term disability benefits. Thanks for tuning in today. I hope you found this episode helpful. Please take a moment to like our page, leave a review, share it with your family and friends, and subscribe to this podcast. I also love to hear from our listeners. At the beginning of each episode description, you're going to find a link where you can send us your questions or comments. I might even feature them in a future episode. So join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.